Welcome, everyone. Can you hear me now?
Yes, yeah.
Okay, good. There was a bit of lagging and a surprised mute. But yeah, welcome everyone to this session. And thank you so much for taking the time to be with us today and for taking the time to not only share your wisdom and messaging with us, but to be in the space of co-learning and solidarity building. Today, as the rest of the days, I have learned a lot and I am really happy to bring this to you as part of the session. So my name again is Angelica Quesada, and I am the Director of Research and Evaluation at the John Humphrey Centre for Peace and Human Rights. So just let me coordinate here to move my presentation forward, or our presentation forward. And so I want to acknowledge the place that JHC calls home, Amaskwaciuskagan, otherwise known as Beaver Hills House, Treaty 6 territory, or Edmonton. Most of my learning and understandings of justice and peace are rooted in that land, and I miss Edmonton, Amaskwaciuskagan quite a bit. I'm joining from unceded Algonquin and Anishinaabe land, or Ottawa, and Praveen is joining from the land covered by Treaty 13, signed with Mississaugas of the Credit, or Toronto. This land has a history that lives beyond and before us and has deeply impacted the realities that we live within today. It is not possible, to do cohesive human rights work without first acknowledging the past, but also the present, displacement and the genocide and erasure of Indigenous peoples that have taken place throughout Turtle Island. This is an acknowledgement that not all voices are heard, and we must make a commitment each day to engage and learn to decolonize. We must acknowledge the history of public systems and law in Canada and how they have evolved and have been founded within an ideology of erasure through policies of displacement, removal, and criminalization. This continues to pervade our systems and require vigilant efforts to use international human rights law to shift and seek accountability. So as we introduced this morning, today we want to talk about accountability and remediation. And part of it is that the systems in Canada. And so I think a few times also we have addressed during the convention how the John Humphrey Centre is part of a legacy of John Peters Humphrey, the principal drafter of the United Nations Universal Declaration of Human Rights. And we are a non-partisan charitable organization based on Amaskwaciuskagan, but also working across the province and country to advance human rights and peace building through education, training, collaboration, and dialogue. I shared with you this morning briefly how JHC has tended to be a place of last resort for people who are struggling with complex human rights issues and who are falling through the cracks. As a result, we have worked to build Stride Advocacy. That is a program that combines a force of volunteers who are supported and trained to become helpers in their community. Their main task is to support claimants to document and file human rights complaints and other remedy spaces offered by other institutions. This strong network of volunteers has been running and consolidating for over 6 years already and works in connection with a group of coalition of agencies that come together to engage in systemic advocacy on issues emerging in our work. Human rights violations of people incarcerated, mental health services for children children aging out of care, and police accountability are some of the topics we're working on at a systemic level with agencies and at the individual levels through the network of volunteers. Through our work with Stride, we came to experience and see the barriers for community members to access and seek remedy through the Canadian and Alberta Human Rights Commissions. It is from this space that we share this research with you today. In recognition of international human rights law, we want to ground ourselves by acknowledging that access to human rights is deeply connected to the intersection of the spaces we live in, the identities we carry, and our socioeconomic conditions. Those intersections define the spaces we take up every day and who has access and who doesn't. The John Humphrey Centre, or JHC, is is committed to understanding those barriers, has committed in the last few years to understand those barriers. And that's where we are grounding in the experience of people who are navigating those systems. And we wanted to understand what were those barriers and how they appear in the process. And so in that, in trying to look for answers to what is happening to people who they are navigating, what is the experience, we started this research path, and we focus on the experience of users. So we wanted to understand how the users of the Canadian Human Rights Commission complaint process first, and we released that report on April 2023, and shortly we follow with the research of the experience of the users of the Alberta Human Rights Commission complaint process, and that report was released in November 2023. In both reports, we follow similar methodological processes, which means that in both research process, we combine interviews with users of the systems and interviews with experts. And we're really proud to share with you the results of these two research processes. So to share our findings, we would like to do it in the following manner. So Praveen is gonna guide us through an exploration of the grounding ourselves in the Paris principles. Then we're gonna present the findings of in parallel, what we found in the Human Rights Commissions, in the Alberta Human Rights Commission and in the Canadian Human Rights Commission. And then we're gonna have a panel to discuss those findings. And then we'll have closing remarks. And so with that, I want to pass it to Praveen, and you'll let me know when I hit play.
Great. Thank you so much, Angelica, for that opening. And thank you, everybody, for joining us here tonight in this really important discussion on human rights remedy mechanisms. But first, we wanted to take a few moments to establish foundations around the importance of human rights institutions. And, you know, that's been the ongoing discussion today, that they really play a central role within the wider human rights systems and within our obligations and commitments under UN treaties. So this includes government-established commissions, agencies, ombudsman offices that were created essentially to provide access to human rights remedy for those that are left behind. So, you know, we really say this as well through our work at Stride at JHC, that, you know, while human rights may exist on paper and we strive to educate the public on them, if we don't have spaces to seek the remedy to those human rights violations, we don't actually have human rights then. They are not real or actualized at all. So we would like to share with all of you just a short video that also explains and sets out the key criteria and competencies of the UN General Assembly for all national human rights institutions around the world. So this is known as the Paris Principles, which was established in 1991. These lay out the standards to guide these institutions that state that these institutions must be vested with the competence, mandate, and resources to fulfill their aims. Angelica, if you could just show the video.
The Paris Principles are the UN guidelines that set out the minimum standards required for national human rights institutions to operate efficiently and be considered credible. The guidelines were developed in Paris in 1991 at a meeting where representatives of national human rights institutions from all parts of the globe were brought together to define the core attributes that all new or existing institutions should have. The UN General Assembly later endorsed the guidelines, and since then, the number of national human rights institutions has increased from a handful to more than 100 worldwide. According to the Paris Principles, there are 6 main criteria for a national human rights institution to operate efficiently. A broad mandate based on universal human rights standards, including the responsibility to promote and protect human rights and combat all forms of discrimination. Autonomy from government. Independence guaranteed by the Constitution or national legislation. Adequate powers of investigation. pluralism, including through membership and/or effective cooperation, and adequate human and financial resources. The competence of the national human rights institutions, as described in the Paris Principles, can be grouped under 5 headings: monitor and report. A national human rights institution can publish reports and recommendations on any human rights violation it decides to take up. It can submit reports to the government, parliament, and other authorities on issues that concern the promotion and protection of human rights. National human rights institutions can contribute to and also express their opinions on reports submitted by the state to the UN and regional bodies. Advise government and parliament. National human rights institutions can advise government, parliament, and other public or private bodies on human rights, both on request and on their own initiative. They can also alert, access, and advise the government in relation to human rights violations in the country. National human rights institutions can examine and recommend changes to their state's legislation, regulation, and practices to ensure that these are harmonized with international human rights standards. Cooperate on international, regional, and national level. National human rights institutions have a clear mandate to interact with the UN and other international organizations, regional bodies, international and national civil society organizations, and other national institutions. Educate and inform. National human rights institutions should help formulate and execute programs for human rights education and research. Handle complaints. Some national human rights institutions also have an optional quasi-judicial competence. This includes the handling and investigation of individual complaints and petitions. The Paris Principles do not dictate a specific form. National human rights institutions can therefore come in different shapes and sizes, but the most common forms are commissions, advisory institutes, ombudsman offices, and public defenders' offices. Because of the diversity in institutions and contexts, the mandates and powers of national human rights institutions can vary quite a lot, but they all work to promote and protect human rights.
Great, thank you so much. And I also put a link in the chat for everybody to review the Paris Principles as well too. And I think it's really important that we ground our discussion today in the Paris Principles, because the Canadian Human Rights Commission is Canada's designated national human rights institution, meaning that it is obligated to uphold and protect human rights, not only enshrined within our legislation, but to also uphold the Paris Principles as well too. And additionally, the Alberta Human Rights Commission, while it is a provincial institution, it is also nevertheless to be guided and grounded within the Paris Principles. So really, using that then to frame our discussion, and, it brings us to the question, why should we examine the Canadian and Alberta Human Rights Commissions and tribunals? And really, it's because these mechanisms are an important part of the fabric of realizing human rights within our communities. And, going off of the theme of today's convention, it is necessary to continue to examine our mechanisms, our national and provincial remedy mechanisms, and to hold them accountable and to ensure that they're transparent. So we need to be able to assess the accessibility of these national and provincial mechanisms, and if the needs of the most vulnerable in our communities and claimants are met within these processes. Because the accessibility of a remediation process should be measured by the experience of those who sit at the intersections of historically marginalized identities and social conditions. So it is extremely vital that external and independent reviews of our national human rights institutions and remedy mechanisms, that they continue to take place, so that we ensure that they're meeting their obligations under the Paris Principles. And so, that was also the intention as well of this research project, to be able to provide that, and to also provide concrete and tangible recommendations to improve the human rights process. If we could go to the next slide, please. Right. So here we have the Canadian Human Rights Commission's mandate, and I do invite you all to just take a moment and read and reflect upon it, and think about again how this connects to the Paris Principles and how, based on Canada's obligations at the international level, how again our national and provincial human rights institution systems, match our system of jurisdictional responsibility within these levels. And so we do invite you as well to as we discuss our findings of the research, to take note of how the commissions are fulfilling their obligations to act as the designated human rights mechanisms for the public, and how they are fulfilling that obligation as they purport to be Canada's human rights watchdog. If we could go to the next slide, please. And here we have as well the Alberta Human Rights Commission's mandate, stating that their mandate is to foster equality and reduce discrimination, as well as providing education programs and helping resolve human rights complaints. And I think earlier today there was a session where we were talking about rights holders versus duty bearers, and there was discussion about how rights holders are the people, essentially, are Canadians and are the public, and duty bearers are essentially state actors who have those legal obligations to respect and fulfill their human rights. So there is this shared responsibility currently within Canada between the federal, provincial, and territorial jurisdictions, depending upon whether a human rights violation falls within their jurisdiction. So I invite you to reflect upon this as we kind of move through our presentation today. So this is essentially a very sort of brief overview of the administrative and legislative barriers that were identified in both research projects. And as Angelica mentioned, the federal research project commenced in 2021. And it was over a year long. And then after that, we embarked on another journey examining the Alberta Human Rights Commission. And we conducted several interviews, qualitative interviews with claimants and people who had engaged with both human rights mechanisms, and as well as experts who had either represented community members with the human rights mechanisms or had engaged with it in other ways, academics, practitioners, other CSOs. And so with this work, we also do want to acknowledge, of course, the people that were able to support us and the organizations such as the Alberta Law Foundation and the Canadian Bar Association, as well as Judge Gurcharan Bhatiaji with the Federal Research Project. And again, the objective really was to hear and examine those firsthand experiences of claimants of the human rights mechanisms to identify barriers to accessing remedies. And so through this project, these two projects, we were able to develop these recommendations to strengthen the process. So essentially, we were able to produce two research reports, one which was produced this past April, the Federal Research Commission, and this past October, we were able to produce the Provincial Research Report. And I'm just going to put those actually in the chat for everyone to take a look at. One moment. So, okay. And I do invite you to take a look at these two reports. It's just some light reading for all of you, as just to dive a little bit further into the findings. But the research identified key legislative and administrative barriers that obstruct the public's access to these remediation processes. So what you see here is a summary of both of these barriers similarly affecting claimants' experiences at the provincial and federal level. And just to note, administrative barriers are really challenges within the Commission's process And the recommendations we provided are directed to the Commission to modify their process in order to strengthen the access to remedy. So the administrative barriers we found were the accessibility of the process in navigating the first point of entrance, and in terms of accessing and understanding the complaint form, the time spent drafting complaints, as well as collecting evidence and documentation and physical accessibility. As well, challenges with communication, approaches, options, and methods within the Commission was also identified as a barrier in terms of not having case updates, the inaccessibility of human rights officers not being easily reached, as well as not having clear timelines for complaint resolution. As well, the lack of lived experience and representation of groups who are seeking remedy within the Commission, the Commission staff and their adjudication process. So there were concerns expressed about representation and diversity amongst human rights officers and Commission staff, and not having that understanding or nuanced perspective of discrimination. As well, there's the lack of internal accountability and an internal review mechanism within the process. So again, this was something that surfaced during interviews where interviewees expressed that they had experienced either mistreatment or perhaps feeling pressured into accepting settlement offers with unfavorable terms against their wishes, or other kind of general mistreatment, and the lack of having a remediation mechanism for that specific kind of behavior. Additionally, there was also what was expressed was limited awareness, knowledge, and understanding of the Commission and its complaint processes. So interviewees and claimants were not aware of the Commission's and how to navigate their processes, and not understanding how to file and draft human rights complaints. As well, a really major issue was the lack of legal representation to navigate the complaint process. So really, needing that legal support or navigation support to help essentially move and engage through the human rights mechanism, and often being up against a respondent that is able to have and retain legal support, it creates a huge imbalance. So not receiving that kind of support or any kind of assistance. As well, a major significant barrier was the negative impacts of engaging with the mechanism on mental health and well-being. So this includes being re-traumatized and re-triggered, especially with people who have experienced discrimination. And it was shared with us the emotional and psychological impacts of engaging with the mechanism, facing perpetrators of discrimination without proper supports and having to reshare your stories multiple times. As well, what was also expressed was that there were limited resolution methods that are being offered through the commissions to resolve complaints other than what is already currently in place: conciliation, mediation, or the tribunal process. And then, just quickly kind of going over then what the legislative barriers that were found. So these are barriers that are rooted more so in human rights legislation. And so these are things that are essentially outside of the Commission's control, and, as they are statutorily restricted by what's enshrined within their human rights legislation. So this would require lobbying the government to be able to address and change these at a higher level. So here we have the 1-year time limitation at both commissions to submit and have human rights complaints accepted, as well. Having both commissions have narrow protected grounds of discrimination under both the Canadian and Alberta Human Rights Act to file a discrimination complaint. So again, these protected grounds of discrimination are essentially identity markers where your human rights complaint is based upon, and they can be quite to kind of distill the human experience down into just an enumerated list, it really doesn't fully capture the experience, the human experience of what it is to experience discrimination. And so there was this need to expand these protected grounds, especially with, grounds such as Indigenous identity, social condition or disadvantage, especially for the unhoused. And that was a topic of discussion in yesterday's day, speaking about poverty issues, as well as political belief, association, or activity. As well, what was identified was the lack of enforcement measures of decisions that are reached at the conciliation and mediation stages, and that stronger enforcement measures are needed at the tribunal stage. As well, having unsubstantial remedies which do not reflect the time or effort to go through the complaint process, and the lack of autonomy from the government and their reporting requirements, the lack of those reporting requirements to the Legislative Assembly and to Parliament. So that was just a quick overview of something that I do recommend that you take the time to just go through the reports, where we provide a much more kind of comprehensive breakdown of the issues, the barriers, and recommendations that we found. So this is essentially just some of the key differences that were found within each research project between the emerging themes or barriers for claimants at these levels. So the Federal Commission, their complaint form has quite a restrictive word limit of 3 pages or 10,000 characters. As well, the Federal Tribunal has a cap on damages awarded for pain and suffering at $20,000 only, which does not adequately reflect the time or the effort to go through the process, nor today's standard of living. Additionally, it was found that disability-based complaints involving issues of transportation are actually not processed at the Federal Commission. They are instead redirected to the Canadian Transportation Agency, which has even less clear guidelines on the reporting mechanism and creates possibly this two-tiered ableist system. And as well, what was brought up in the federal research project were the challenges that are facing incarcerated complaints and claimants. And, I was really thinking about this too during our day on prison justice and advocacy, and just those significant barriers that are in place for incarcerated individuals. And, we should acknowledge as well that the Commission does accommodate incarcerated claimants in terms of things such as moving deadlines and conducting conciliations through the phone. However, it does not take into consideration these unique conditions that they are under, that they're experiencing, such as threats to their safety and retaliations potentially by their oppressor, who is responsible for their care, as well as the lack of access to internet and access to phones to contact lawyers and to participate in meetings. And as well, enforcement is even weaker within correctional institutions for any incarcerated complainants as well, too. And then for the Provincial Commission, so what was of significant note is the reduced funding that is allocated by the Government of Alberta to the Commission, as the budget of the Alberta Human Rights Commission has been reduced by almost 13 to 15% adjusted for inflation over the past 10 years. So resulting really in a significant decreased amount of resources and provisions of service to the public. So again, they have not received an increase in funding since 2015. And, resources have not been scaled as the Commission has grown and the number of complaints have increased. And to give everyone some perspective, the Federal Commission operates on a budget of, I believe, approximately $31 million per year. And in 2020, the Commission saw 49,000 submissions of complaints and accepted over 1,000. The Provincial Commission, in contrast, accepts nearly the same amount of complaints each year, however, with this significantly different budget capacity. So that was definitely something that was of note with the Provincial Commission. As well, there were also just another note on the limited protected grounds of discrimination at the federal level. They also included within the Canadian Human Rights Act genetic characteristics and conviction for which a pardon has been granted, which the Alberta Human Rights Act does not include presently. Okay, if we could move to the next slide. Okay. And so this is a summary of the proposed legislative solutions. So we do recommend that an amendment to the human rights legislation increases the time limitation to file a human rights complaint from 1 year to 2 years. As well, that policy research be conducted to understand the impact and incorporate new protected grounds of discrimination into the human rights legislation, including but not limited to Indigenous identity, social condition or standing or disadvantage, genetic discrimination or genetic characteristics, as well as political beliefs, association, or activities. As well, we recommended an amendment to both human rights legislation to define clear enforcement powers and measures for the Commission to enforce remedies prior to the tribunal hearing stage. As well, that the commissions be separated from the federal and provincial government by having the Commission report directly to Parliament and the Legislative Assembly of Alberta, to ensure that it is that they are being held accountable and that they are independent as well. Additionally, we recommended an amendment to increase or remove the cap on damages awarded from $20,000 and to also codify or include systemic remedies such as reinstatement for those of whom have lost their job. And we also have recommended increasing the amount of funding received annually by the Alberta Human Rights Commission by the provincial government. Okay, next slide, please. Thank you, Angelica. Okay, there we go. Okay, so this is a summary of the proposed administrative solutions from both research project. So for accessibility, we recommended offering diverse formats for users to access the complaint process by incorporating instructions, recommendations, and intakes in a variety of formats such as video, audio, and sign language, and that all of it is in plain language. As well, integrating reliable and consistent communication channels or avenues within the process, and providing clear case updates and case check-ins, and integrating briefing sessions, expanding their hours of operation. As well, we recommended that a diversity audit be conducted and be made publicly available of Commission staff and employees. As well, providing mentorships or internships specifically for underrepresented communities, and providing anti-oppression and diversity, equity, and inclusion training for all current and incoming staff. Additionally, it is also recommended that the commissions continue to conduct and collect disaggregated data on complaints. And there are efforts right now by both the federal and provincial commissions on collecting data on complaints. However, we recommend that they collect retroactive disaggregated data, and also on complaints that were not just accepted, but those rejected at the outset of the complaint process, which may reveal unique demographics that are not yet identified that need specific supports. Additionally, we recommended that an internal remediation mechanism be built and supported to address concerns of treatment that were received by Commission staff, and also to revamp the Commission's role in public education, and including the Commission's role, information about the complaint process and relevant human rights legislation. Building a strong social media presence and campaign to raise awareness, and revamping, essentially reviving the Human Rights Education and Multiculturalism Fund within Alberta to be able to provide more education efforts about the Commission's role in upholding human rights within the province. And ideally, of course, it would be ideal to be able to have legal representation for community members engaging with the mechanism, but unless there are resources provided, we then did recommend that the Commission's focus on building an internal team to support users to navigate and understand the complaint process, and establish partnerships with groups that are already doing that work. And then also integrating trauma-informed or healing-centered practices into the complaint process by including mental health supports and providing a list of these mental health supports and resources that are free or affordable. We also recommended integrating alternate dispute resolution processes, including arbitration and restorative justice practices, and making available a list of mediators and organizations that facilitate these processes, including Indigenous knowledge keepers and restorative justice associations. And then the last three that you see there that are bolded on the slide, these are specific to the Federal Commission. So to lift the word limits within the process, as well as strengthening inclusion of disability-based complaints involving transportation, and as well as strengthening accessibility for incarcerated claimants within the process. And so that was a very quick overview of two years distilled down into half an hour. And I do welcome as well everyone's feedback and thoughts. Our next steps forward really are taking these recommendations and engaging with partners, with stakeholders to try to implement these recommendations, and to also work with both of the commissions, to be able to improve and strengthen the process as well too.
Okay. So do you want me to stop that presentation now, Praveen? Should we move into the...
Sure, yes. And I'm also just dropping a Mentimeter link in the chat for your feedback. I know we kind of sped through all of those barriers and recommendations, but we do really invite you to share your thoughts as well on the pathway forward. So thank you.
Okay. So as Praveen said, 2 years of work, nicely put by her in half an hour. But I guess what is the most important for us right now is to start thinking about how do we implement and how do we start moving these recommendations forward, and what kinds of collaborations, and what is the path. And I wonder, it seems to me that I'm lagging a bit, so I just want to, am I okay?
No.
Technically speaking? Okay, good. So the second part of this session is not only, our intention was to share what the research had brought up to light for us, but we want to have a conversation with two amazing people, really knowledgeable and experts that are going to help us go a little bit farther into understanding the human rights systems in Canada and bringing things up. So I'm going to help moderate, and Praveen is going to be one of the members of the panel. So I'm going to introduce you, Praveen, because I think that we haven't given you the proper acknowledgement here on this research. So Praveen was the lead researcher within the JHC, and Praveen Parmar is a lawyer and a human rights advocate from Alberta, passionate about social justice and access to justice. She's currently working as a human rights officer with the John Humphrey Centre for Peace and Human Rights with their Stride Advocacy program, helping the public navigate human rights mechanisms, and has conducted research examining barriers to the Alberta Human Rights and Canadian Human Rights Commission. Previously, Praveen was a student at law at the Ontario Institute for Cancer Research, where she was called to the Bar of Ontario in 2021, and she was selected in 2018 as a legal fellow for the Young Lawyers International Program, implemented by the Canadian Bar Association and Global Affairs Canada, which places lawyers and law graduates with various organizations around the world to work in the areas of human rights and development. And she worked with the UN Women Program Office and the Human Rights Team under the Office of the High Commissioner of the Human Rights in Belgrade, Serbia, and Arlington Human Rights Commissions in Washington, D.C. Praveen, we're really honored that you're part of JHC, and so thank you for being part of the panel. And I'm going to now introduce Robert Phil. Robert was part of the research team of the Alberta Human Rights Commission research. We were supported by a fantastic group, and Robert was one of them. So Bob was previously the chief of Alberta Human Rights Commission, a provincial court judge, a respected lawyer, and an adjunct professor at the University of Alberta Faculty of Business, a resident of Edmonton City Centre for the last 24 years. Robert has held executive board positions on numerous community organizations, including Boyle Street Community Service, Reach Edmonton, Edmonton Community Legal Center, Yellowneck Men's Recovery, Hope Foundation of Edmonton, and the Mayors of Edmonton Task Office to End Poverty. Robert received the Queen's Gold Jubilee Medal in 2003 and the Alberta Centennial Medal in 2005. In 2017, he received a Distinguished Service Award from the Alberta branch of the Canadian Bar Association and the Alberta Law Society. He continues to be a mentor to many young lawyers and students, and had several notable appointments to the Law Society committees in Alberta, the Northwest Territories, and Nunavut. So thank you, Robert, for being with us and for all your support during this research. It was really dear to us. And last but not least, Linda McKay-Panos. Linda is the Executive Director of the Alberta Civil Liberties Research Centre. She taught language arts and social studies with the Calgary Board of Education for 7 years before returning to the university to obtain her Juris Doctor and Master of Laws degree at the University of Calgary. She practiced law for the time before joining the Alberta Civil Liberties Research Centre in 1992 as a research associate. Linda is a seasonal instructor in the Faculty of Law and Arts at the University of Calgary. Linda is the author of several publications dealing with civil liberties, access to information, human rights, discrimination, equality, and related topics. Linda received in 2001 Suzanne Ma Award and the Alberta Centennial Medal in 2005 for her work in human rights in Alberta. So we're really honored to have you, and we welcome the two of you to this conversation. And so I want to first of all capture your first reactions to the research. I wonder if we can start there. So Praveen, this is not for you, but I wonder if Linda, we can start with you. Like, what are your first reactions to this research? And I'm gonna take the time to stop the presentation so my computer can relax a bit. So Linda, go ahead.
So first of all, you're to be congratulated on your research. And I was very pleased to see what you came up with on your recommendations and so on. At the same time, I have to be honest with you, I was a little sad because the first project the Research Centre ever did was on hire to the commission, the Provincial Commission. And they haven't improved as many things as I would like, as I would have liked. Some of the same things are coming up again. And I'm pleased, though, because you confirm a lot of the things that we considered. And one thing I want to point out on a positive note is I just got a newsletter from the Alberta Human Rights Commission, and they actually have a link to some recent cases, and that is new. So that's a positive. Listening to somebody. And so we also did in 2019, much more recently, a procedural recommendation report. And the problem we ran into, and I think I'll end with my initial remarks, is this. The commission staff were quite receptive to a lot of our suggestions. But the problem is the law was changed by the legislature, and the commission staff don't always have a say in the legislation that's passed. And so my recommendation to you would be, and this may sound a little off kilter, but we had some success recently in doing something similar with police complaints, is to submit a copy of your report to all the members of the legislature in Alberta, because that'll give some fodder to the opposition to start, holding the feet to the fire. What are you doing? What's been happening? And some of the justice ministers have been quite open to our suggestions. If it looks like it's something that you're doing from an honest, independent, and you're not trying to attack the government, you're trying to help them, they're more open to. That's why I suggest that. So I'm glad you did it. Disappointed that it hasn't improved more, but we're coming. It's slow, right? So.
Thank you, Linda. Bob? Robert?
Oh, thanks, Maria. First of all, without getting too professorial, and I don't know who's on our call or in our presentation, but one of the things you have to understand is that in our Constitution, jurisdiction is divided between the federal government, and their jurisdiction is set out in Section 91 of the Constitution, and the authority of the provinces is set out in Section 92. So the reach of the Federal Human Rights Commission is very limited. It's limited to those industries that are regulated by the federal government, like banking, airlines, interprovincial trucking, shipping and navigation, those kinds of things. And of course, also to their employees. So there's probably about 1 million people that fall under that jurisdiction. And then the provinces all have their own individual human rights legislation. And I think in Alberta, we're probably about 4.5 million people who, of all ages, obviously, that fall under the jurisdiction of the Provincial Human Rights Commission. So the Provincial Human Rights Commission has a mandate in the areas of employment, services customarily available to the public, and accommodation. And most of their complaints arise in the area of employment or services customarily available to the public. Now, our human rights legislation and the Alberta Human Rights Commission just celebrated their 50th anniversary. So it came into existence in 1972, and it was then called the Individual Rights Protection Act, and it morphed over the years to the human rights legislation. But back in 1972, when they were debating the legislation, an opposition MLA stood up and said, "You can have all the high-sounding language you want. It looks to me like the Human Rights Commission is underfunded and under-resourced." Fast forward 50 years, The Human Rights Commission is underfunded and under-resourced. And we have to do better in our outreach. One of the things that I think there ought to be a possibility, take somebody that's disabled, getting from wherever they live to an office in downtown Edmonton is a struggle. So maybe 2 human rights officers, obviously for safety purposes, could attend at their home or meet them in some location that's convenient for them. The other thing that happens is we assume that everybody that approaches us with a human rights complaint is literate. And that's an assumption we ought not to be making. And, there are countless things that we can do to improve the outreach. It shouldn't look like it's remote from people, and it is. And if you want to see remoteness, look at the Canadian Human Rights Commission. Now that's really remote, but we have to do better. And the thing is that Parveen laid out in the overview are all things that are doable. And the question is, what's your government? What's your level of commitment to human rights? Are you serious about this? And for example, and I'll end on this, you have a process that talks about conciliation and coming to a resolution. So you get a resolution and it says the respondent, let's assume it's an employer, we'll do X and Y and Z, and they will pay some damages. But you can't enforce that. And there are other provisions, both in the human rights legislation and in labor legislation, where if you get a favorable ruling, you can take that decision and file it with the court as like a judgment of the court, and enforce it. And I can tell you that at one point in time, I used to do all the legal work back in the 1980s for the Human Rights Commission, and I did that more than once. But hollow remedies don't help anybody.
Yeah.
And that's much of what we do. And finally, the independence piece should be an office of the legislature, should report directly to the legislature. The hallmark of independence, and this is more commonly rolled out when we're talking about the courts, but the hallmark of independence is security of tenure, security of remuneration, and administrative security. And human rights commissions have none of that. And that's where we have to go. And that's my Saturday night rant.
Thank you for that. Such informant. And so let's think a little bit and explore what is working and what has changed lately, perhaps, that is working today, or that has allowed some kind of movement for either the federal or the provincial commissions. So I don't know, Parveen, if you want to start this one, and then we will move it.
I mean, so I do think we have to give credit where credit is due and commend the commissions on their efforts, to try to review at least parts of their processes. I know that that's the case. For example, the Alberta Human Rights Commission over the past year has been undertaking or asking the public for feedback on their website, which is often the first point of access that the public has to the commission, because it was quite outdated, and not, having links that worked, or resources that were unavailable. And so they modified and relaunched their website to be more user friendly, as well. One of the recommendations was collecting disaggregated data on the complaints within the mechanisms. And while this is something that now both the federal and the provincial commissions are collecting, it's not retroactive disaggregated data. So we're not able to understand, the systemic issues within the commissions, and also potentially those claimants that are living at, perhaps multiple intersections of identities. And so it's really crucial for commissions to collect that retroactive disaggregated data, but also complaints that have also been rejected. So I think that there are things that commissions are trying to actively improve upon. I know at the federal level, again, they have been trying to, take sort of a closer look at their internal kind of accountability, whether it's their anti-racism action plan, or, I think most recently this past spring, allegations of discrimination within their commission staff as well too. So I do commend them for taking that look, but I also think that there's still a long ways to go in terms of whether or not, it's meaningful enough, whether or not if it's inclusive, and, kind of just trying to work together with the commissions as well to get them to that point in time, to be able to be accountable.
So Linda, what is working?
Well, I think they are I don't have as much experience with the federal Human Rights Commission. It's mostly with the provincial one. And they have been very good to support some of the initiatives that we have tried to do, especially education initiatives. And I think some of it's born out of necessity because they don't have the money to do it. But we are certainly grateful that they are partnering with various agencies to do this work, and obviously are willing, at least to a degree, to look at their processes. I also, you have to know that you mentioned the website. Well, that was back in the 90s. That was one of the main recommendations that we had. You don't have a website at all. You need to get one. So they've come along quite, and I'm glad they're looking at more about it, because this is the way many people, not all people, access the information. I think until they're out from under the thumb of the government, it depends on the government of the day. When we did our recommendations, and I'm sorry, Robert, I don't think you were on the commission then, but the fact of the matter is the staff were actually afraid to share the recommendations to the government because they thought they would close the commission down. So if they're working under that kind of fear, they're not going to get very far, because they're afraid. They need their independence. And I think, they try, but I think until that is gone, so that they have appropriate funding, appropriate autonomy, there's always going to be some challenges, because if they try anything new, depending on the government of the day, they may be looked at challenging the government or attacking the government. And I think they've done a stellar job of negotiating their way through a number of different governments. But you have to know, by the way, in case you think I'm slamming the Conservatives, it was a Conservative government that actually started the Human Rights Commission in Alberta. So it was Peter Lougheed's government. So Anyway, I kind of got off a tangent, but I really wanted to get my 2 cents in worth the fact that they are listening to some recommendations, and I think that is a positive thing.
Yeah, thank you. Robert?
Yeah, I think that civil society organizations, with the greatest of respect, because I did much of this when I was at the commission. No point in talking to me. Talk to the government, because and you have to somehow get their attention. For example, the whole question of if you look at the definition section in the Alberta Human Rights Act, it says religion includes native spirituality. Okay, but we have to do more, in my view, for the Indigenous community. Now, much of the activity of people in the Indigenous community, if they're on reserve where they live or where they work, then they're going to be under federal jurisdiction.
Mm-hmm.
But I think the numbers now in Edmonton are we have about 60,000 urban Indigenous people in Edmonton. So any complaints that they have are going to be with the provincial government. And we've seen in the last few months, we've seen a tremendous reason why we have to improve our efforts at education. And the commission at one point in time had a pot of money that they could accept applications from community groups, civil society groups, etc., and let them study a human rights issue, or engage in a project of some kind. That's gone. That's gone. And
Mm-hmm.
The import of human rights, I like to think, but you never know, that no government, right, left, or center, would abolish the Human Rights Commission.
I hope so.
But what I would like to see on the advocacy side is maybe there's a place for an office of administrative advocacy. So you could have trained people that would deal with human rights complaints, privacy commissioner complaints, ombudsman complaints, those, and there might be others, I don't know, but skilled people, almost like an administrative legal aid. Because, if it wasn't for administrative agencies, government couldn't function.
Mm-hmm.
Government couldn't function. And we need people that would have that independence, because there was a time when the commission, when I did all their legal work, I did all their inquiries. It's rare that the director's office goes to bat for a complainant. And there's nothing more difficult for a court or a tribunal when you have a self-represented individual. That doesn't mean that their complaint is not meritorious.
Mm-hmm.
They just don't know how to deliver the message. So there's lots to be done, but I think the real answer is commission. We appreciate what you're doing. We know the limits on your authority, and let's talk to the politicians.
Good, great.
I got to stop ranting.
So we think you have talked about like the points of entrance, the importance of the webpage, and the importance of education, and how they can do it in collaboration with organizations. and that administrative advocacy. Let's talk a little bit about the model and the alternative models of remediation. Like what is the what are the commissions using, and what is the possibility to transform those processes or to use different existing models of remediation that is not only mediation? Is there any, what other models can we implement, and what is that possibility? Is that possibility real? And so let's start with Robert this time, and then we will move around.
Well, that's not fair. I just finished ranting, and now you want me to rant. There's got to be, first of all, clearly, in my view, we have to increase the limitation period from 1 to 2 years, and there are some human rights cases that demand and cry out for a decision by a tribunal because the behavior is so egregious, and we know that most settlements that people get in the human rights process or any legal process almost always include a non-disclosure clause. Mm-hmm. So there's no educational value in the settlements, and I think there could be, and I think you could still respect the privacy of people by redacting the settlements, and it would be a useful tool for people to say, well, Charlie was in a similar situation and he got X, and I think there has to be a reality. I mean, one of the things that people maybe don't appreciate is that you hear people saying, well, they're suing for a human rights violation. Well, we don't sue for human rights violations in this country because the common law never recognized a tort of discrimination. They come close a couple of times, but all of the remedies are statutory. Mm-hmm. And so we have to make that system work better, both from the point of view of entry and the exit part, and make it meaningful. And I'll give just one example of something that people probably take for granted. But when you go into a movie theater in this country, all of them have wheelchair cuts, and they have companion seating next to those wheelchair areas. And why did they do that? You think it's because Cineplex Odeon is a good corporate citizen? They may be, but they did it because there was a human rights decision that said you got to give people access to the movie theater because it's a service customarily available to the public. And so the next time you go to the movies and you see that area in the theater, reflect on that. That's there because of a pardon me, a human rights remedy. So I don't think, Maria, I answered your question. I don't know how you got me so fired up on Saturday night, 2 weeks before Christmas.
It's not me. It's our fire to get justice and remedy to people here. So, Praveen, what's your take on that one?
Yes, yeah. So, this was an issue that we explored as well through both research projects, was whether or not we should implement in Alberta something called the direct access model. And this is a model that's currently being implemented in two other provinces and one territory in BC, Ontario, and Nunavut. And really what this model allows is it permits all parties that file complaints to go directly to essentially an adjudication panel or a tribunal without fear that their complaints will be dismissed before being heard. And so this was kind of essentially a way to allow people to have their voice, as opposed to what we currently have in Alberta and in all the other provinces in Canada. The human rights commissions are often referred to as a gatekeeper model because they determine at the outset which complaints shall or shall not proceed to adjudication, depending upon whether or not they meet some sort of evidentiary standard to move forward. And so, there's questions about whether or not this is effective. Even within the research project, the experts that we engaged with also recognize that, well, yes, the direct access model might result in faster resolution and theoretically allow people to essentially have their complaints be heard. But again, it will not happen without proper funding, and that there were also a number of backlogs and delays, because within the direct access model, users of this model are expected again to kind of file their individual complaints, have complete carriage of their complaints with the tribunals. There's no kind of administrative body in between that then conducts investigations, and users are responsible for the carriage of their complaints. So, it's also been criticized essentially for preventing access to justice by screening out complaints and preventing users from accessing justice. So it's definitely an ongoing debate. And on the flip side of that as well too is that, for example, in Ontario, there's then been a separation between the Ontario Tribunal, which adjudicates and oversees complaints, versus the Commission, which then is able to focus on its mandate of human rights education to the public and providing those programs. So there's also that argument that perhaps separating the two will then permit, a body to be able to carry out that education within Alberta, which is very much needed. But again, it goes back to resources and, working with and putting pressure on the government to be able to make that a priority.
Mm-hmm. So, Linda, I wonder if I can ask you the same question, but I want to add a piece that just popped up on the chat, and is what remediation measures can the government provide to complainants with the actual model? Like, what are the possibilities of remediation? What are the measures that can be achieved today?
Which model? Sorry? Can you say the name of the model again?
Oh, we were talking about the model that Praveen was talking about of
the direct access model. Well,
yeah, go ahead.
So, what I like about the Ontario system, because we looked at that too and recommended we consider it for Alberta, is that I find, like, when I'm doing research on human rights issues related to discrimination, I find that the commission part is doing some excellent work and keeping really up to date on research, which is very helpful for education and information. Now, with regard to the part about direct access to tribunal, I really agree that if you do away with the investigation part, that's a very serious miss, because it used to be, even they've tried to reduce the number of investigations they're doing in Alberta, because the idea is to move everything along as quickly as possible. Yeah. They want, and they can see files, and they can make recommendations for what the remedy should be. And although the commission doesn't have to follow those recommendations, then I think if you use that more often, and if you had a broader array of remedies available, those could be part of the recommendations. The idea of just going straight up and being your own counsel and, without anybody looking at what happened, I think it sort of defeats the overarching purpose of the acts, which is not punitive, it's educational. How do you think what please don't do it. Learn from your mistake. And I think, like ideas of restorative justice and all that kind of different models would be awesome. And just one more side comment about the current model. We don't do advocacy at the center, but I have to tell you, I spend about one half of my time on the telephone with people who are going through the human rights process, who are completely disturbed about what's happening, and how long it's taking. And like the other side's got legal, like say a person representing themselves before the tribunal, and the other side's got a bevy of lawyers because it's a big employer or something. It's just so unfair. And it's not their fault. They don't know how it works. This is like, it's a kind of like, I recommend, first of all, if you can go trial, so you go on. Well, it's not easy. So,
We've lost you, Linda. You were frozen.
Oh, I'm sorry.
That's all right.
Are you okay now? My computer, we got too many people in my neighborhood that use Wi-Fi, and it freezes all. Is it okay now? I just wanted to say I liked your idea of having an administrative legal aid of some kind to help people, because a lot of our important life decisions are made by administrative tribunals nowadays.
Yeah,
absolutely. And that model already exists at the Workers' Compensation Board, because they have workers advocates, right? If you're injured, and there's a standalone group that will help you, through the process there, including the appeals commission. And I don't know how many agencies would come under that umbrella of an administrative advocate's office, but clearly Human Rights Commission, Privacy Commissioner, the Ombudsman, maybe AISH, but it and and most lawyers that I know that might be interested in that could get up to speed pretty quickly. I mean, and certainly it's something that's worth exploring. And the good thing about it is that it would also have an arm's length relationship from those agencies, the Human Rights Commission, the Privacy Commissioner, the Ombudsman, or whatever. I think that there's some room, and maybe in the courts there is what is known as a victim fine surcharge, right? And so and maybe there could be a human rights surcharge against the respondents if they're found to have breached the act, and that money could go to the education fund. And the human rights fund that we used to have, that money came from gaming. Well, the last time I looked, there's a heck of a lot more gaming going on, so there must be a lot more money in gaming. So how about sending some over?
Yeah. So let's move into some of the questions that people are asking, and there's one, and I wonder if perhaps one of you want to take it. Are there any other countries whose mechanisms do much better than Canada, to model off them?
Well, I'll take a stab at that one first, and but the I think the European Union has a pretty vigorous model, and I think the EU is 26 or 27 countries, maybe 26 since the United Kingdom got silly there a few years ago and got out of it. But they have some pretty vigorous, and Linda, I don't know if you've ever looked at their jurisprudence, but it's not a bad model. I mean, our American friends use what they call Title VII under the civil rights legislation in the United States, and that's a litigation model where you sue, and it's a model that applies universally. In other words, there's not a divided jurisdiction over human rights matters like we do in Canada. But I'm not sure. I'm not in favor of the traditional litigation model because it puts poor people at a decided disadvantage. There are organizations in the States that help a lot, like the American Civil Liberties Union and organizations like that. But you have to get them on a good day with the right case. That's the problem. So that's my rant on are there better models?
Yeah. Praveen or Linda, any of you want to add?
I just wanted to skip back to the previous question for a second. I just wanted to mention, I give a shout out to the pro bono students program, because these are law students who are interested in various issues, and they are, depending on what school you're at, what law school you're at, they are helping people. It's kind of like a mini administrative. They're not full-blown lawyers yet, and they need supervision in that. But I just think that they deserve some recognition, because they're definitely filling a gap that's out there, and they're not. But getting back to the other one, I agree with Robert. I think the European Union, the Human Rights Committee, and all over in Europe is an excellent model that should be looked at. They have a great deal of power, and I agree that we don't want to go into just pure courtroom, because those of us who've studied law know that in general the number one remedy is money in a court. And think about certain things, like somebody who wants their job back. A judge can't order that in our current system unless it's a special contract case or something. But in any event, I think if you're looking at broader remedies, you don't want to don't work.
Hi, Linda. We lost you.
Oh, for God's sakes.
We lost your last sentence.
I just said I don't think we want to use the court system if we want to entertain broader kinds of remedies and things, because they just don't have the capacity to do that.
And Linda, we are going to advocate for everybody having the right to good Wi-Fi.
Yeah. Well, and I won't mention my server, but I'm always fighting with them.
Okay. and what are their initials? Roger Shaw, or?
Yes, they would be.
That's their initial. Yeah.
So we have 6 minutes to close, and I'm wondering if we can close with some remarks from all of you about what and I know that we have an array of issues, but I wonder if you can share with us perhaps what is one, like what is the most important thing that you would say, um, let's go for this change. And Praveen, let's start with you.
Sure. I think as well with our work through Stride, helping claimants through the system and seeing those negative impacts on their mental health, being re-triggered, re-traumatized. So I would honestly say I would focus on supports, whether that's mental health supports or having either that legal or human rights supports to navigate the system. Because if you don't know your rights, you're not able to actually realize them or claim them, right? As rights holders versus duty holders. And so I do think it is crucial, absolutely crucial, to be focusing on those legislative recommendations, but that is something that we will have to work with the commissions and lobbying the government, working with the government to be able to make those changes to human rights legislation. So while I think the focus should be absolutely there, we also still can't forget in the meantime then, because that is going to take quite a long time. We have to kind of work together, and advocacy is always about that collective sort of mobilization and slowly chipping away at it. I do think as well it is absolutely necessary to focus on providing those supports and what's within the commission's control as well too, and whether that's looking and reimagining what the process is like, what the supports that are provided, really simple kind of accommodations that can make the process easier for somebody to engage in, that is being vulnerable and brave, coming forward and sharing what they went through, which is essentially having their human rights violated. So that was kind of my ramble, my final thoughts.
Okay, Robert.
First of all, I want to echo Linda's shout out. I'm an advising lawyer for the students at the U of A and the Human Rights Project, and it's interesting, it's fun, it's challenging, and the students do great work. For me, I think the number one thing, and my friend Ron Gitter, who was responsible for shepherding the human rights legislation in Alberta through the legislature in 1971-72, has created an organization called the Dignity Forum. And their principal mandate, not their only mandate, but their principal mandate is education. We've got to get something back into the school system from K to 12. And I would say that, and that is more apparent to me in the last few months, and given what's happening in Europe and what's happening in the Middle East, and if we can't come to a better understanding of each other, we're going to be in serious trouble. And I will end with that. And by the way, if you're interested, that was not a rant.
Thank you, Robert, for closing with words of peace and bringing us together. Linda.
I turned my picture off because my
your audio is still breaking up, Linda.
Oh, crap. What you've all said, I apologize for my Wi-Fi, and I think it's just have to hang in there. We have to continue what we're doing, support each other.
I think the last thing we hear from you was support each other. So let me take that to say that I think that the measure of success in one of these conversations is how fast it passed. And time has gone by like this for us, and for what I have seen in the chat, everyone just didn't feel the time. So thank you so much for such an interesting, profound, and we can continue going on this conversation because there is a lot to do. But I think one of the clearest messages for me is we gotta continue supporting. Oh, hi, Kat. Continue supporting. I think that there is a lot of responsibilities that we should take as part of organizations or as part of educational institutions to promote and kind of like poke the change in conversations with the government, conversation with the commission, and with supporting each other and supporting the community that needs those services to achieve remediation. So thank you again. I know there were some questions that were unanswered in the chat. So hopefully if you have questions about how the process works, maybe we can get in contact with us and we might be able to support you. And I want to thank you all, Praveen, Robert, Linda, for fantastic conversation, and everyone for holding with us. And remember that we have the movie Nechem at 7 p.m. Mountain Standard Time. And thank you for another successful panel. Have a good night.
Nice to see everybody.
Linda, when you used the word crap a few minutes ago, is that a legal term?
Yes, it's a short form of something else.
Okay. Thanks, everybody, and I hope that the folks that tuned in got some value from this. And
I hope so too. Do we know how many people? Just for
so let's allow this to finish, and then they are going to tell us how many people is it.
Oh, okay. Thank you.
Thank you very much.
Good night, everybody.
Good night, everyone.
Thanks.